Hi, I'm Brian with Hanning Law Unlimited, attorney for businesses and creators. And today I'm going to talk about what happens when someone's using a similar name or logo to a registered trademark. And the first thing to do is research. So you're going to want to know what kind of situation you're looking at. Is it someone you know? Is it someone across the country? How formal do you need to be? What's their offering? Because your job is to protect your trademark. And so that can include some less than kind words being exchanged if appropriate. But really you want to kind of understand what the situation is and what will happen if you talk to them versus if you hire an attorney to talk to them. You need to be aware that hiring an attorney can escalate the situation, and it can also diffuse it because it can be a indication that you have counsel and they may look at it and go, we don't, we're just going to comply. So it's really going to depend on what's going on, how much a particular attorney becomes relevant, or what the conversation pieces are. So when you have someone using a similar trademark, be it words, logo, design, etc., the first thing you're going to want to do is communicate with them. That's going to be either you getting on the phone and giving them a call, sending them an email, or hiring an attorney to do a formal demand letter. And those elements are basically going to say, hey, you're using my trademark, you got to stop. And going from there. A number of times that is enough to resolve the situation because it can be an awareness thing, right? Where nobody really wants to step on other people's toes, but at the same time, it may not be enough. It may be a situation where that letter is the beginning of a communication and we have a negotiation going back and forth. Or it may be where there's a communication, there's a negotiation or not, but parties get set into their positions of one party saying, hey, you're infringing on my trademark, and the other party saying, no, we're not, we're fine, we're doing something completely different, it's not a problem. At that point, you may want to look into whether or not pursuing litigation is appropriate. Like we've talked about, one of the benefits of trademark registration is benefits around litigation, access to federal courts, statutory damages in certain cases, attorney's fees in extreme circumstances. These can make it so that it's not as big of a cost to go pursue the case, but it may not be appropriate in a given circumstance. So you're really going to want to look at the situation and review and see what makes sense for the context. With that, I would suggest taking a look at my video on demand letters and also just doing your research. Like I said, is this actually an infringing mark, or is it just something that you don't want them to use? Because that may change your approach. All things being equal, you're going to want to start with a demand letter just because it's relatively inexpensive and frequently creates a resolution that is more acceptable than pursuing litigation where even if you win, it may cost such a substantial amount without triggering some of these things that it can be significantly problematic. One of the things to consider is the infringement test. What is one of the main tests that we look at? And for that, I'll talk about it next week.